So at this time, the chair would lay out House Bill, I apologize, 3073 and recognize Representative Howard.
Thank you, Chairman Smithy and members, for the opportunity to lay out House Bill 3073. Similar to other bills, especially even earlier in this particular hearing, this layout is particularly significant because today is the beginning of Sexual Assault Awareness Month. According to the Texas Association Against Sexual Assault, 2 in 5 women and 1 in 5 men in Texas have been sexually assaulted. The Rape, Abuse, and Incest National Network estimates that out of every 1,000 sexual assaults, only 230 are reported to the police. 46 will lead to an arrest. 9 cases get referred to prosecutors. 5 will lead to a felony conviction. And only 4.6, I don't know how we get to 0.6, but anyway, 4.6 rapists will be incarcerated. In Texas, data from the FBI shows that in 2020, over 13,000 rapes were reported to Texas law enforcement agencies, but only 3% of those got a full investigation and trial. This is why HB 3073 is paramount. Far too often in our state, perpetrators of sexual violence are not held accountable for their actions because our laws do not adequately reflect the experiences of crime victims and do not provide a clear definition of how consent is to be communicated and understood. This is the urgent crisis that House Bill 3073 seeks to address. This bill is a top priority for the Governor's Sexual Assault Survivors Task Force, and I am honored to author this bill along with my Senate companion author, Senator Angela Paxton. Before I begin my layout, I'd like to clarify, excuse me, Mr. Chairman, there was a committee sub.
Oh, there is a committee substitute, so Mr. Wu will lay out the committee substitute.
Thank you.
Okay.
Appreciate that. And just to clarify, the committee substitute just omitted some apparently confusing language, put in original language back in, and that's basically it. Okay. I wanted to clarify one common misperception about the Texas Penal Code. When the Penal Code references sexual assault, it is talking about rape. This is not to be confused with indecent assault, which is commonly known as groping. House Bill 3073 is not talking about indecent assault. It is about sexual assault, which again, per statute, is synonymous with rape. House Bill 3073 makes important and necessary updates to the state's consent laws, and we just mentioned the committee substitute, so got that cleared up. First and most importantly, House Bill 3073 provides clarity on the definition of consent, aligning it with the definition used throughout the rest of the Penal Code. As y'all know, I'm not a lawyer, so in layperson's terms, the Penal Code's definition of consent means that consent is given voluntarily and actively and can be either explicitly stated or communicated through actions. House Bill 3073 also adds that sexual assault is without consent if the actor knows or reasonably should know that the other person is intoxicated or impaired by any substance and cannot give consent. When drugs or alcohol are involved, current law states that the actor must intentionally impair the other person by administering the substance. Thus, those who are intoxicated on their own volition or who are drugged by one person but raped by another are not protected. And finally, this bill further clarifies that consent can be withdrawn once an act has been initiated. Consent is not a one-time event, but an ongoing process involving continuous communication and mutual agreement. Current Texas law does not acknowledge a person's right to revoke consent at any time. House Bill 3073 does what current law fails to do. It encompasses the essence of what a sexual assault is. It's a theft. It is a theft of what is most precious to each and every one of us, our person. Texas law already recognizes that a person commits theft if they take something without the owner's effective consent. In other words, we require the presence of a yes, not the absence of a no, to define theft. If a person is drunk at a bar and another person steals their wallet, we will all agree that this is a theft. The thief would not be able to defend themselves by saying that the person was drunk and seemed to be okay with them taking their wallet. However, if a person is drunk at a bar and another person takes advantage of them sexually, current law allows for the perpetrator to defend themselves by saying that they were drunk and simply didn't know that it wasn't okay to do. This disgusting loophole in the law must be closed. Instead of placing the burden on the survivor, we should focus on whether or not the offender had consent to have sex with the victim in the first place. I would like to note that effective consent is currently used as the standard to determine if a person gave someone the necessary consent to use their property, their vehicle, their coin collection machine. Multiple other states have similar provisions in their laws concerning sexual assault, specifically relating to intoxication of the victim and the right to revoke consent. These are not liberal blue states I'm talking about. These states include Oklahoma, Arizona, Idaho, Kansas, Montana, North Carolina, and South Dakota. I want to reiterate what I said at the beginning. 2 in 5 women and 1 in 5 men have been sexually assaulted in Texas, but fewer than 3% will ever see their abuser behind bars. I urge you to join me and the governor's task force in supporting this bill that will hold rapists accountable for their actions and protect future victims. I'm happy to try to answer any questions here. I reserve the right to close. I know there's some witnesses.
Thank you, Ms. Howard. You know, we have heard, as you mentioned, similar legislation, and we've gone through some of these issues. Last week, I think, and unfortunately, I don't think we had this bill referred or something. It's hard to do both of them at the same time, so we apologize for that. But we appreciate it, you're bringing the bill. Appreciate your witnesses. Any comment or question? Mr. Little?
Thank you, Chairman Smithy. Representative Howard, I spent a bunch of time with your original bill last night, and I'm looking over the committee sub. Mm-hmm. Can you just share the reasons for the committee sub? Because there were some pretty significant changes from your original bill, and
My understanding of it is that what it did is it removed incapable of appraising the nature of the act or resisting it, and just keeps the unaware that the sexual assault is occurring. That part of this had to do with some confusion that was apparently expressed by some over the language there. And so just returned it to the original language because it didn't seem to really be something that was significant enough to keep that language in, when that's not what the intent here is, to define consent.
And I'm struggling to understand. So the addition on B3, which is, it is now or unaware that the sexual assault is occurring. So the bad actor has to know that the other person is unaware that the sexual assault is occurring under your change. And I'm trying to understand what the bill is targeting, because it makes sense that a bad actor would know that the other person is unconscious. I don't know what we're trying to pick up with or unaware that the sexual assault is occurring. Like, how is that different from unconscious, and what is it that we're trying to pick up? Do we know?
I'm trying to understand your question, so let me just see if I can look at the language here. I don't think I totally understand your question.
Yeah, I'll try to ask a better question. I'm struggling to ask it too, but we're trying to, your addition or unaware that the sexual assault is occurring, what are we trying to pick up through the addition of that phrase that we don't have right now, either through unconscious or something else?
What I'm going to ask is that we let one of the experts respond to that.
Okay.
If we could, please.
We already took a really hot lap on this, the concept or the rewrite with Representative Ann Johnson. And I'm still trying to grasp it myself, so that might be helpful.
Okay, thank you.
Any other questions? Thank you, and we'll give you the right to close.
Thank you, and I would suggest Summer Willis be called up first if possible, Mr. Chair.
Will do.
Thank you.
Okay. Chair calls Summer Willis.
My name is Summer Willis, and I'm here representing myself in support of House Bill 3073. Thank you, Chairman Smithy, Vice Chairman Wu, and the committee for having me here today. Last week, I stood before you as an advocate and an endurance athlete. Today, I'm returning as one of the thousands of survivors in Texas whose bodies became crime scenes, whose stories remain untold, and whose justice remains denied. First, I want to address the concern about intoxication. On the night I was raped, I wasn't just drunk, I was targeted. While fraternity brothers competed over who would get to take me home like a trophy to be won, one handed me a drink that turned my world into a blur. My last memory isn't of consent, it's of desperation. Running, falling, cutting my knees and my hands, a memory of searing pain that briefly pierced through the chemical fog. I woke up, confused, naked, violated. When I asked what happened, my rapist laughed. He laughed and told me what he had done. Days later, the worst thing that ever happened to me was documented in their fraternity newsletter, distributed like the trophy announcement it was. I know there are concerns about what happens when both parties are impaired by alcohol, but let's be clear, alcohol didn't pin me down. Alcohol didn't ignore my incapacitated state. Alcohol didn't strip me naked, and alcohol did not brag about my violation, my rape, afterwards. People make mistakes after drinking too much. They say something embarrassing. They send a regrettable text or wake up with a hangover. But there is a chasm of difference between a regrettable choice and predatory violence. Alcohol does not get to be a get-out-of-jail-free card. Alcohol should not keep this bill from passing. Secondly, I've heard concern about false reporting. These concerns are inflated by sensationalized media and schoolyard hypotheticals, despite consistent evidence showing that false rape accusations occur at rates no higher than other violent crimes. But we never hear concerns about false reporting when it comes to crimes like robberies or home invasions. Instead, in those spaces, we allow the law to focus on protecting the innocent. Here's my closing statement, sorry. I'm not just asking for your vote, I'm asking you to look survivors in the eye, the ones you know, whether they've told you or not, and tell them whether Texas will continue to be a state that leaves consent dangerously undefined, where survivors are left wondering if their rape even counts. Thank you.
Members, do you have any questions? Rep. Little.
Thank you, Chairman Wu. Summer, thank you for sharing your story again with us. I think after having taken a couple passes with this, I think I'm starting to gain a better understanding of what's really a very complex statute. In your situation, I think you spoke about this last time and a little bit today, it seems that the primary problem with the statute is that unless the bad actor caused the impairment, meaning unless the bad actor personally administers the drug or gets that person drunk, there's not criminal culpability. Isn't that really the key
Correct.
issue? So
Yeah.
I think in Representative Howard's bill, her committee substitute, which is different from the one that I reviewed last night, B6, I think that's the rifle shot right there. The actor knows or reasonably should know that the other person cannot consent because of intoxication or impairment by any substance. So if I'm hearing you correctly, the purpose of the modification primarily to the statute is to protect a victim from a bad actor when that bad actor was not the one who intoxicated the victim, but it's some other third party. Isn't that what we're dealing with in targeting?
That's one of the situations, yes, sir.
Isn't that the primary concern of what we're trying to address, is to protect people who have become incapacitated for some reason that is not attributable to the rapist? Isn't that right?
Yeah, and I think it also covers people who are intoxicated.
Or maybe by their own
Yeah,
Yeah.
out of their own volition, and then they end up getting raped behind a dumpster at Stanford or bruised at the Harvard campus. My advocacy is around college campuses and realizing alcohol is drunk, but that does not equal consent for that person.
And I think just hearing your story a couple of times helped me really understand that. I think B6, the modification to B6 in the committee sub is the bullseye. I think it addresses that issue particularly well. So thank you.
It makes me really happy that my story was able to shed some light on
Yes,
this.
ma'am.
Thank you.
Any members? Thank you. I just want to ask you a few questions, and just to be clear, I think, and if you can't address these, I'm sure Rep. Howard can. Like, this is, we're not doing this bill because you're asking for it, right? Like,
Yes.
this is a nationwide movement to change these laws because it's been decades since we've realized that these were problems, right?
Right.
Okay. And this bill is being worked on not only by the reps, but also by a lot of lawyers in the governor's office and around here. Like, this is something that everyone is paying very close attention to, correct?
Yes, it's something we really need to change in Texas.
Thank you.
Thank you.
Members, any other questions? Next is Samantha McCoy. And I show you representing yourself,
Yes,
and you're testifying for the bill. Is that all correct?
correct.
Thank you very much. Please proceed.
So thank you so much for your time today. I'm here to testify in support of House Bill 3073, which clarifies the definition of consent. My name is Samantha McCoy, and I'm here as a survivor. For far too long, survivors of sexual violence have faced impossible barriers in their pursuit of justice, barriers that have emboldened perpetrators, silenced victims, and left communities vulnerable. During my junior year of college, I unfortunately had a very similar experience to Summer, who was just up here. I was physically beaten and violently raped while I was unconscious. Within days after the attack, I would additionally find out that the perpetrator had filmed the rape and disseminated the video online and to people I knew as a way to further re-victimize me. Horrifyingly, the video plainly showed that I was not moving, not responding to anyone or anything. I made the terrifying decision to report the perpetrator to law enforcement because I could not live with the thought that he would possibly do it to someone else. Without any advocate or support person, I made a report, underwent a rape kit examination and photographs of my injuries, and complied with every request that investigators made, including countless and repetitive questions, and painfully having to wiretap the perpetrator without any guidance or forewarning of how terrible it would be to hear the person who had just beaten and raped me on the other end of the phone. Despite my efforts of undergoing traumatic treatment by law enforcement, who asked me questions such as, quote, "If you were unconscious, then how do you know you didn't consent?" In the end, the legal system turned its back on me. No charges were filed, no justice was served. I was left with the fear, knowledge that the attacker remained free, and the horrifying realization that our laws have failed to protect victims like me. Current Texas law states that the perpetrator must intentionally impair the other person by administering a substance. House Bill 3073 strengthens the definition of consent to include when the perpetrator knows or reasonably should know the victim cannot consent to by intoxication or impairment of any substance. Had this law been in place when I was assaulted, I believe justice would have been within reach. Survivors deserve better. We deserve laws that acknowledge what happened to us and hold perpetrators accountable. Restoring faith in our judicial system means ensuring that every survivor's voice matters. I urge you to advance House Bill 3073 for every person who finds the courage to speak out, protect others, and demand change. Thank you.
Members, any questions? Thank you.
Thank you so much.
Next is Nicole Martinez. And I have you testifying, representing the Governor's Sexual Assault Survivors Task Force, and you're neutral on the bill as a resource witness, correct?
Yes, sir.
Okay. Please proceed. Members, are there any questions for this resource witness? Could you tell us a little bit about the work in the Governor's Sexual Assault Survivors Task Force and how this bill was brought about, what kind of work groups were put together, and who was a part of those things?
Absolutely.
Thank you.
Vice Chairman Wu. Again, my name is Nicole Martinez, and I am the administrator of the Governor's Sexual Assault Survivors Task Force. As Representative Donna Howard mentioned earlier, the task force was established in 2019. We have 26 members of various state agencies, statewide coalitions, and professionals and disciplines who interact with survivors on various levels. Also, the task force has 12 focused working groups, and those focused working groups are smaller groups of task force members, subject matter experts, advocates, survivors, and victim family representatives. They meet as needed to discuss complex topics such as consent. One of our focused working groups is the prosecutor working group, which has been established probably about 4 years and has representation from various district attorneys' offices to include Brazos County District Attorney's Office, Harris County District Attorney's Office, Dallas County District Attorney's Office, Tarrant County DA, Smith County, Williamson County, Jasper County, Gregg County District Attorney's Office, and the 81st Judicial District Attorney's Office. Including those prosecutors that serve on the prosecutor working group, we do have survivors who, one is present today, Lavinia Masters, and a mother, Tracy Matheson, the mother of Molly Jane, and the founder and president of Project Beloved, the Molly Jane Mission. These individuals and subject matter experts have met for the past, again, 4 years, talking about how can we, as a statewide task force, make amendments to the current statute for sexual assault offense. How can we ensure that survivors, when they report to law enforcement, their case will be accepted by the district attorney's office. As we've heard earlier, the stats for those survivors who choose to report are very few. Those who do choose to report to law enforcement, very few cases are picked up by the district attorney's office. And if they are, very, very few are prosecuted successfully where those offenders are held accountable. So these prosecutor working group members, again, combed through our current statute as well as other state statutes to determine the best way to empower prosecutors to be able to successfully prosecute these types of cases. As mentioned before, this bill, as with the committee substitute, will allow prosecutors to hold those perpetrators accountable and have a clearer understanding of what these circumstances, how they happen, and be able to provide justice for survivors.
Okay, thank you. And Mr. Little?
I think
Oh, I'm sorry.
Representative Ramos had a question.
I'm sorry.
Thank you. Oh, I'm sorry.
No,
Did you
go-
need to recognize me?
Oh, no, go ahead.
Okay.
Is that okay, Mr. Little?
Please.
Will you defer to
We
Mr.
should.
Rodriguez-Ramos?
Yes, sir.
Okay,
Thank you. In addition to what the Sexual Abuse Task Force is doing, and you mentioned earlier, and then the stats show it, that people do not report or traditionally don't report it sufficient numbers, and I know this legislation is to help advance that. What are some other initiatives that the task force is doing to encourage more reporting so that there could be more meat to this legislation?
We have passed previous bills to mandate law enforcement training so that they have a better understanding of what trauma looks like and how to better interview and investigate these types of cases. We have also passed legislation to require emergency department staff to have a better understanding of what sexual assault is and the dynamics, as well as trauma. We have enhanced the certification for sexual assault nurse examiners, as well as improved their training. I could go on and on and on, but we aren't just tackling this from a criminal justice perspective, but a collaborative and coordinated response with all professionals and individuals who come into contact with survivors throughout their healing journey.
Okay, thank you.
Okay, Mr. Little?
Thank you, Mr. Chairman. Ms. Martinez, one of the novel aspects of Representative Ann Johnson's bill was the addition of criminal culpability for persons who impersonate trusted individuals like mental health services providers, clergy, coaches, and tutors. Did your task force consider any of that in its recommendations or formulating this bill? And do you have an opinion on it?
We did not discuss that, and I do not have an opinion on that. I do know that there is a current prosecutor here who may be able to give you additional feedback in response to that question.
Okay, thank you.
Representative Little, may I also bring to your attention that subsection 3 that you expressed concerns about earlier, the language regarding or unaware that the sexual assault is occurring,
Yes, ma'am.
is not new language. That language is actually taken and relocated from subsection 5.
I'm sorry, I've got to get back to it. Just 1 second. Okay. Why was it moved from 5 to 3? I want to think about what you said. Okay. Do you know why that language was relocated?
I personally do not, but I have a feeling Representative Howard will be able to address that
She
in her
very well may.
closing.
Are you satisfied that the committee substitute addresses the situation or the problem posed by Ms. Willis's testimony that where the victim's intoxication is not attributable to the conduct of the bad actor?
Yes, sir, in
Okay.
addition to others.
Yes, okay. Thank you so much.
You're welcome.
Thank you for being, we appreciate you being here. The chair calls Dr. Bertha Lavinia Masters.
Versus in the act.
Thank you, Chair Smythe. I am Lavinia Masters. I'm here to represent myself in support of House Bill 3073. Let me say I'm really a nice person. I don't want to come across as a mean person. I just have such passion for the work of survivors of sexual violence because of all of the trauma I've been through, not with just being sexually assaulted at 13, but a college incident where I was drugged and raped by a young man and his brother. And at first I kind of laughed. I say, it's April Fool's. And so I know we're not still talking about consent because I know I didn't give consent on that night. I kind of blocked it out of my mind because unfortunately for the family of this young man and his brother, when they came up for the Grambling Prairie View game, they died in an auto accident. I didn't report the crime because I felt that no one would help me because after my rape at 13, no one was there for me. But I use the analogy, if you leave your homes open and a rapist just decided to come to your neighborhood and he said, I'm going to move in with you, how would you accept that? That's how I look at this. This is like you leaving a door open and we decide we're just going to, a rapist just decide he's going to come in and just reside with you. And you pay all the bills and you feed them and you do all of these things. It's asinine is what it is. And that's what I see in this, where we can't make a decision of what consent is, even if we've been drinking or we've had drugs. My drugs were not intended. I didn't ask for the drugs. I had been drinking, but they put the drugs in my drink. And so I'm here to support that. And I also need you to know that the door was left open with this bill, and we need to close that door today. Consent is like healing after sexual trauma. It's perpetual. It should be ongoing. We have that right to say, I decide to do this, or I decide not to do this with you today. So that's all I have to say about this. I want to keep it nice and simple because, like I said, you'll see me again. You have any questions?
Ms. Jones has a question.
I want to say this, Mr. Masters, it doesn't matter if you can't be angry and upset about what happened to you
Yes.
and angry and upset about a loophole
Yes.
that makes you prove something,
Yes.
then when can you be angry and
Yes,
upset?
exactly,
Right?
exactly, exactly.
So, and I think just by the very nature of you coming up here and
Yes.
advocating for people other than
Yes.
yourselves,
Yes, ma'am.
that shows that you're a good person.
Thank you.
So let me
God
start by
bless you.
saying that.
Thank you.
And the last thing I'll say is that as it applies to consent is this. Just because, even if I go get drunk,
Yes,
I'm not getting drunk saying, okay, you get to spread
Yes.
my legs.
Yes.
Right? You don't,
Yes.
That's not what I'm saying.
No.
And we need something to protect people. Sometimes
Yes.
we make mistakes. What
Yes.
if you pretend like you're the parent of, I don't know, a girl, a young
Yes.
girl.
Yes.
Right? Sometimes when you take your first drink,
Yes.
like you don't have a high tolerance.
Yes.
You'll
And
take
that's me.
something, right? And then you
Yes.
drunk. Do you want for somebody to be able to take advantage
No,
of
ma'am.
your child?
absolutely
So,
not. Absolutely not.
And I just think it makes it clear. I think there are a whole. I went to a bunch of keg parties when I was in
Yes.
high school.
Yes,
Thank God I didn't drink.
Yes,
Right.
yes.
But I saw
yes,
the behavior.
Yes,
Right.
yes.
It was like a heat session.
Yes, it
right?
was.
The people are drinking beer. The guys were trying to figure
Yes.
out who they could get.
yes, yes.
And it will cause you, because if this law
Yes.
passes, and then parents can teach
Yes.
their kids, hey,
yes,
right, if she's drinking, you might not
Yes.
want to do that,
yes,
right? Because you
Yes.
might end up locked up.
yes, yes,
So it's a whole opportunity to make people be held accountable for their actions,
exactly.
right?
Exactly.
And taking responsibility, it'll make you stop and pause. So
Exactly.
I think you're a good person,
Thank
but I
you.
think if you can't be mad under this circumstance,
Yeah.
then when can you be mad?
Exactly.
And so I appreciate
Exactly.
you.
Thank you. Bless you.
Yes, thank you for being here.
Thank you.
Ms. Bowers has a
Yes,
question.
ma'am.
Thank you, Chairman Smithy. Thank you, Ms. Masters. I do know you to be very kind, and I do know you from the legislation that our former colleague, Representative Victoria Niave Criado, lifted with the Lavinia Masters Act.
Yes,
And
ma'am.
so I want to thank you for doing that for the rape kits that were sitting on the shelves collecting dust, and also just for continuing to use your voice. So, thank you.
It's necessary.
Mhm.
Thank you.
Yes, it is. Thank you.
Thank you.
And one more, you're not finished, Ms.
Okay.
Rodriguez-Ramos has a question for you.
Thank you, Ms. Masters.
Uh-huh.
You know, I asked the previous witness in terms of what else the state is doing to increase reporting.
Yes,
And I
yes.
appreciate you sharing the story and
Yes.
the other witnesses. It's an absolute act of courage, but I'm always concerned, like, if we have all this legislation,
Yes.
but people are still not reporting,
Yes.
and I understand why, and all of
Yes.
the different facets, but as you explained a little further, I think this is the answer to that, right?
Yes,
Like, I'm like,
yes.
okay, if we do all of these laws, what's it gonna change? But
Yes.
but that's changing the burden from
Yes.
the perpetrator,
Yes.
from the victim to the perpetrator, is what
yes.
the answer is, I think, and
Yes.
it'll empower and encourage other individuals like you and the
Yes.
others that testified here today. I want to
Yes.
thank you, because it's
Thank
an
you.
absolute act of courage to come out here and share your story, and for our other witnesses. But I'm hoping this is the answer, so that we can increase those
Yes.
numbers of these, because we know these perpetrators are probably doing it again and
They are.
again. And
They
if
are.
we don't speak out, especially young women or women in general, that putting that burden on the perpetrators, I think will
Exactly.
help.
And if I may add, I'm already ashamed that I was violated. I carry that
Right.
shame. And now I was shamed because I drunk a Matilda Bay. Those who are in their 50s may remember that. But I drank a Matilda Bay with someone I trusted and said he liked me and this and that. But I guess because I wasn't giving it up, as they said, they decided to take it. So that's the burden. So now I have the shame. I'm shamed that I drank, that I went out, and hung out and thought I trusted people, could trust people, and it didn't go as I planned, and it was very scary. And I didn't report because, of course, my first rape, nothing happened. It sat on the shelf for 20 years. So now, how can I trust my justice system to protect me now? He's going to say, I know her, my word against his. And so this is what happens. And a lot of victims will not report because of those kind of actions. They see what's in the news, what we put out in social media, what's public, and how it looks like Texas will not protect me if I come forward and report. And I think it's important that we continue to advocate and we put out there that we will protect you. We are fighting for you. Please come forward. Please give us that evidence. Please report these incidences. Don't leave everything out high and dry. We are here for you, and that's why I continue to do the work, and I appreciate you all for supporting us and doing the work with us.
Well, and you talked about the shame.
Yes,
This puts
ma'am.
the shame where it should be, is on the perpetrator
Yes,
who
ma'am.
violated,
Yes,
who
ma'am.
then has to prove that,
Yes, ma'am.
there wasn't any
ma'am.
consent, and that's where the shame
Yes,
should
ma'am,
be.
exactly. And that's when my first perpetrator, when I found him out, I post him everywhere because I'm like, shame on you. Your mama
Yes.
should know what you do in the dark, your grandma, your grandpa, everything, because I carried that weight for far too long, and it wasn't mine, it was yours to bear.
That's
And so
right.
now you own it.
Thank you,
Thank you.
ma'am. Appreciate it.
Thank you very much.
Thank you.
Tiffany Larson.
Thank you. My name is Tiffany Larson. I represent the Brazos County District Attorney's Office as well as myself in support of House Bill 3073. Representative Howard couldn't have said it better. Sexual assault is a taking. It's just taking something that you want that the other person isn't willing to give. But when we talk about a taking, in order to take, you have to have a power imbalance. And that is also what we're talking about here. That power imbalance can look different in different cases. It might look like a gun or a knife or strong-arming someone to the ground. But in so many of the cases that I review, it's much simpler than that. It's simply a vulnerability. One person is in control and the other person is not. All of us know what it looks like when someone is impaired. We see it all of the time, and we're very, very able to recognize when someone isn't okay. They're no longer really in control of their body, and they don't really know what's going on. Perpetrators can see it too. They do see it, and they take advantage of it. Very importantly, as a prosecutor, I really want y'all to understand we are not trying to criminalize two consenting adults who get intoxicated and have sex. We are looking at that power imbalance, and we are looking for a person who is taking advantage of someone who is not in their right mind while they very much still have control of their own. If somebody knows what they're doing and the other person does not, and they sexually assault them, that needs to be a crime that is very clear. And right now it is anything but. As we mentioned earlier, Representative Little, the unaware sexual assault is occurring. We've had that on the books for many years, but no one knows what it means. And that is a huge problem when you're in a courtroom trying to explain it to a jury. And we want to be able to explain this very clearly to a jury. We do want to increase reporting, Representative Ramos. It's so important that our survivors know that when they come forward about a case like this, I have some means to hold the perpetrator accountable. I won't be able to file a charge every time. We probably won't be able to file a charge in many of these cases. But this will give me a fighting chance to hold someone accountable when the evidence supports that obvious power imbalance and clearly what is a sexual assault. I just also want to briefly answer your question about impersonation, if I may answer that question, Representative Little, because I am familiar, and I may have even been the one to mention it to Representative Johnson in a courtroom because I did practice in Harris County for a number of years. We had an individual who pretended to be a doctor. He put on a lab coat and put out an advertisement asking young women to come and apply for an assistant position. Now, as certainly possibly gullible or naive as it may have been for these young women to believe that he was a doctor and to believe they were applying for a real position, part of his application process was that they each had to come into a restroom and give a sample, and he penetrated them. Now, he will tell you that he had their consent, but it was anything but consent because it was based on a lie, it was based on fraud, and he was not a doctor, he was a scam artist. I don't have a statute right now that protects the individuals who were victimized in that case, and it was a lot of legal gymnastics trying to figure out how to charge it appropriately. And so the idea behind that particular statute would be to take the legal gymnastics out of it. If you pretend to be a medical professional or you pretend to be administering medical care and you are not, and you achieve that consent, but you're now penetrating someone based on that fraud and deception, it should be a crime in Texas. And unfortunately, I have other examples from my time in Harris County. So it's not really a one-off, and it's something that needs to be addressed. And I'm very excited to hear that it might be happening this particular session.
Thank you, Ms. Larson.
Thank
Any
you, sir.
questions, members? Okay, Mr. Wu.
Thank you so much for your testimony, and I just want to touch up on, like what you brought up earlier, saying that we're not going after people who are both clearly intoxicated and both of them didn't know what's going on. There's nothing in this legislation that tells prosecutors to like turn off their brains, right?
That's exactly correct. Thank you so much, Representative Wu, and I know that you are a former prosecutor from Harris County, and I think that that is very important. I've been kind of making some jokes about not ever really being accused of overcharging this crime. No one is ever going to be reporting that we are doing this too much. If anything, it's the opposite. We are underreporting, underutilizing our investigation tools, and underutilizing our prosecutorial abilities in prosecuting this crime. But it's mostly because we have cases where there's good evidence and we don't have the right statute for it. We will always use our discretion, and we always have to make a good decision about whether or not we should be prosecuting any particular crime. Because as we all know, that still has to carry in a courtroom, and there's a heavy burden on the state, and we don't want to, and all of us in prosecution feel the same way. We would never want to put a survivor through a secondary trauma of a trial if we didn't think we had the evidence to support the charge. So we take that very seriously. But we're definitely conceiving, and I've worked very closely on the SASTIF with Nicole and the rest of the team to find a way to build into the statute that we currently have an ability to prosecute good cases that we believe in and we support and we have the evidence to support, but we just don't have the right language to do it.
Thank you very much.
Thank you, sir.
Thank you.
Okay, thank you. Okay, Mr.
Yes,
Cook.
sir.
Just going back to the language that Representative Little was talking about earlier, B6, do you have it in front of you?
Yes, sir.
So I just want to clarify. So as far as the situation where the rapist is claiming that he was too drunk to have known or whatever, is this the best language we can possibly have that the actor knows or reasonably should know? Is that as close as we can get to addressing that situation?
Yes, sir, I believe that it is. In the criminal cases, we of course have to prove up that important mens rea component. And so we do still have to show that the perpetrator knows that the other person is not consenting. That's always been true of our statute. It is hard for us to do that in certain cases where two people are intoxicated, but again, we're looking for that power imbalance. Generally speaking, in these cases, the other person really should have known, or maybe even we can prove did know, that the other person was too impaired to consent. But right now, what we have is just that unconscious or physically unable to resist or unaware that sexual assault is occurring. And I'm sorry to say that I have heard defense attorneys tell me that if she was unconscious, then maybe she just doesn't remember consenting. We've got to take that out of the equation. I shouldn't be having to explain to a jury the nuance of unconscious and whether or not we're going to take that literally or not. Representative Jones talked about jury charges earlier. When I have to write a jury charge with the current language, it is very, very difficult.
I know we need to move on, but
Yes, sir.
But mine's more about going back to the mens rea.
Yes, sir.
I want to focus on reasonably should know. Is that sufficient? Is that the best language we can come up with? It just seems.
Yes,
it still
sir.
seems,
I can appreciate why you're grappling with it. We did the same. The reasonable person standard is certainly something that we're very familiar with in criminal practice, and that's what we're trying to get to the heart of here. From a reasonable person's perspective, should they have understood that the other person was not consenting? And in this instance, I think this language will help us do that.
Thank you.
Thank you, sir.
Thank you for being here. We
Thank you.
appreciate it. Members, is there anyone else here to testify for, against, or on House Bill 3073? If not, Ms. Howard, you want to close?
Thank you, Mr. Chairman. And I just want to, Representative Little, just say that from my understanding now, having talked to others, is that that language that is, or unaware that the sexual assault is occurring, already existed. It wasn't current. And it just got moved for clarification purposes rather than just being a standalone section. That's all there was to it. There's no more meaning to it or significance than that, is my understanding. Just wanted to make sure we pointed that out. Yeah, sure. Well, thank y'all so much. I think we recognize that we need to do a better job of getting people to report. This is one of the ways we can make that happen if people have trust that the system is actually going to move forward with the prosecution. And that's something that we obviously haven't seen happening. And prosecutors have told us this is one of the ways that we could strengthen the language and give them the tools they need. So I think it's time we started placing the burden of proof on the perpetrator to prove that they had consent in the first place rather than continuing to shame the survivor. And I hope for your favorable consideration and
Well, we appreciate you bringing the bill, and also, while we got everybody here, appreciate the task force members for the
Yes.
time that you've put in, and for
Absolutely.
some, a lot of you, it's been hard. It's been hard to actually do the work, and I know we understand that. We appreciate you being willing to give your time and effort to do this, because it does make a difference. I think it results in a better work product that we can work with.
Thank you,
here.
Chairman. I think it's evident that these people have put in lots of time, lots of thought in this, and they are the experts in the area, so I'm hoping we can listen to them.
Yeah, it makes our job a lot easier. I know
Absolutely.
that. So it makes us look better by
Absolutely.
passing better bills, so we appreciate
agree.
that, too. Thank you very much.
Thank you, Mr. Chairman. I close.
Oh, just hold on.
Oh, just
Mr.
real quick.
Edwin,
Learn how to dance.
you got to be quicker.
I know, apparently.
Representative Howard, thank you for this bill. It's a little bit easier to understand. The substitute is even, it's better than your original bill even. Even I can understand it. I would just encourage you, and this is your bill, obviously, and you're very experienced at this, far more experienced than I am, but I think Representative Johnson's inclusion of those impersonation provisions that we were discussing earlier is actually germane to your bill and really helpful. So I would just encourage you to consider adding those into your bill if you have an opportunity, because your bill obviously has a very good chance of being heard and passing.
Well, I appreciate that, and it was not in the recommendations from the SASTF, which is what this came from, so that came separately, as you heard from Ms. Larson. So
Yes, ma'am.
thank you for that. I appreciate it.
Okay. Thank you very much for being here.
Thank
And
you.
if there's no objection, members, the chair will withdraw the substitute and leave House Bill 3073 pending for now.